Thank you to our previous panel. There is always something interesting to be learned from such a group of seasoned hoteliers. As parts of our nation, our society, and our economy reopen, owners are faced with a number of challenges. Their first priority is to ensure the safety and well-being of their guests and employees. It seems like we're still learning more about the virus every week. With a few notable exceptions, most hoteliers are not medical professionals. We are relying in good faith on the guidelines that public health agencies are providing us as we reopen safely and smartly. But there is this nagging suspicion that unscrupulous trial attorneys and plaintiffs could start treating alleged COVID-19 transmission as the new drive-by lawsuit. It's bad enough that owners have to worry about getting sick and keeping their guests and employees well. But to have potential lawsuits facing their business after following guidance from their government to fight COVID? No owner should have to ask, will I get sick and will I get sued? Our next speaker specializes in labor law, liability, and consumer protections. She is a partner at Hamilton, Miller, and Birthisel LLP, and is going to address liability issues in the age of coronavirus and what steps small businesses can take to protect themselves. Please welcome Jennifer Miller.
A pleasant good afternoon to everyone. It's great to be a part of the AAHOA virtual convention for 2020. Thank you for inviting me to speak today on the topic of COVID-19 legal concerns, what's top of mind for hoteliers in 2020. I'm Jennifer Miller Brooks, as I was just introduced, and it's a pleasure to be here with you all today. So, what a crazy year. Thankfully, it's half over, and we're now at the point of reopenings. We still have no vaccine. There are a host of new guidelines which tell us what we should and shouldn't be doing to protect ourselves and our guests and employees, and those guidelines are ever changing. So what do we know? We know that liability lawsuits are an inevitable part of operating a hotel. But with coronavirus, we are presented with a new legal frontier. It's a matter of when, not if, a wave of litigation unfolds against hotels. From plaintiffs claiming they were exposed to the virus during their hotel stay. So let's begin by looking at what law applies to such lawsuits. First, we look at the standard of care. Now, we have a bit of insight here as to how these claims will be asserted based on what we saw and the types of lawsuits that we saw against the cruise line industry when the norovirus hit the cruise line industry a couple of years back. And we also have begun to see some claims being filed against hotels and cruise lines for COVID-19 exposures. And so we are now able to garner some important insight from these lawsuits as well. We believe that the standard of care that will be applied in most COVID-19 exposure cases is going to be reasonableness under the circumstances. In large part, the first cases that are being presented are claims of emotional distress. These are claims where people are claiming they attended a large event or a large gathering at a hotel, for example, and now they are fearful that they have been exposed to COVID-19. We will talk a little bit more about these types of claims and how those purely emotional claims are problematic for the plaintiffs. The second issue we will address is causation and why we believe this will be an uphill battle for most folks who bring COVID claims based on exposures. But first, let's get into what is reasonable. Now, reasonableness under the circumstances is considered based on the pandemic and what we see going on with the pandemic. Keep in mind here that what is reasonable in February of 2020 is a totally different criteria than what is reasonable 6 months later in August of 2020. And that is based simply upon the amount of sheer knowledge, or we'll say back in February of 2020, the lack of knowledge that we all had about this pandemic. And that standard will be compared to, say, a year from now, when obviously we'll have more information. In other words, the more we learn about this virus and how it spreads, the more vigilant we as hotel owners and operators will need to be with respect to our efforts at curtailing the spread and minimizing the risk to our employees and guests. So what are some of the sources of reasonableness? What will the jury or judge, in any case, look to determine whether or not the hotel in any particular case met the standard of care? They will look to guidelines. Whose guidelines will they look to? They will look to the Center for Disease Control guidelines, the CDC guidelines, World Health Organization guidelines. They will look to hotel industry guidelines, and those guidelines that each and every individual hotel has promulgated, those policies and procedures that you promulgated related to COVID-19 and reopenings due to COVID-19. The courts will look to state, federal, and local rules and regulations as well. And those will all be sources of the standard of reasonableness. What is the reasonable standard of care to be exercised in the hotel setting? Now, the next list that you have before you, while not exhaustive, it includes the various steps which have been deemed reasonable by all the various agencies when utilized to protect against the spread of this disease and to minimize the risk of exposure to individuals. In the context of litigation involving a hotel, for example, a plaintiff could assert a claim based upon the hotel's failure to take appropriate precautions, such as providing hand sanitizers, providing sanitizing wipes, switching to disposable dishware, having employees wear protective masks or gloves, or its failure to engage specialized cleaning companies to clean and sanitize the hotel. If, on the other hand, a hotel has exercised due care by implementing these policies and procedures and enforcing that folks comply with those policies and procedures, the risks are severely minimized when you do that. The next aspect of minimizing risk involves warnings. Of course, we as folks in the hotel industry are well aware of the benefit of providing warnings in the context of slip and falls and other tort claims. The same applies when you're talking about a potential COVID lawsuit. The good news is that at this point, both the federal, local governments, as well as medical professionals have made COVID exposure and the risk of exposure and how you can potentially be exposed common knowledge amongst the population, at least within the United States. So that bodes well for the hotel industry because most of the general public is aware of how to protect themselves from a general risk. The issue with respect to COVID claims against hotels is what particular or special risks might be present at the specific hotel that specific hotel may need to warn its customers, guests, or employees about. So that requires a risk assessment. That risk assessment is made by management of the particular hotel to determine whether or not there's any out of the ordinary risk associated with COVID exposure at the hotel. And then that may be something that you may need to warn more particularly about. And that brings us to our guidelines. Upon reopening, prudent hoteliers have developed infectious disease response plans that have implemented measures to prevent the spread of the virus to guests and employees and third parties. And prudent hotel owners and operators have developed policies and procedures to protect their employees and staff. We've all done that. So, in so doing, what we need to keep in mind is that it is more likely than not that as a hotel owner or operator, you will be judged by your own strict compliance with your own guidelines more so than anyone else's guidelines. So the key here is to make sure that we remain diligent in following our own internal guidelines. We as attorneys see it all the time in the context of a deposition of the representative of a hotel or another industry head, for example. We see when that representative is questioned at deposition, they are then confronted by the 20-page document, which is their COVID-19 safety protocols and procedures. That representative is on the stand, confronted with those procedures. And what ends up happening more often than not is that the hotel then ends up having to pay a large settlement. Why? Because during that deposition, when asked whether or not there was strict compliance with all of the 20 pages of policies and procedures, the representative, unfortunately, oftentimes has to admit that there was a failure on certain fronts. And so the key here is compliance. The key here is compliance with your own internal guidelines. Once you've promulgated them, they will be used against you. So the key is strict compliance. The next question that's been asked by most of us attorneys in the hotel industry as it relates to COVID is, does a hotel owner or operator have a duty to warn, and who does that warning need to be directed to? And this comes in the context of employee or guest exposure, a known case of COVID-19 exposure either by the hotel's employee or a hotel guest. So you've done your due diligence, you've set up your policies and procedures, you have all your guidelines in place, you're complying with all those guidelines, you have your safety checks, you have your safe distance stations, you have your touchless counters at check-in, you've done your cleaning, and you have complied with all of that. Now you have a guest in the hotel or an employee in the hotel who's been diagnosed with COVID. What is your duty to warn others who are potentially at risk? In this context, we are looking at, again, guidelines from federal government, guidelines from our local agencies, and guidelines from our medical professionals. We have to balance the duty to inform others who may have been exposed of their potential risk with our duty to maintain the health and privacy of the medical condition of the individual who was exposed. So in keeping that in mind, we are always to consult with our medical experts, our local agencies, and follow their recommendations to a T. That is how you minimize your own individual risks. As hoteliers, we do not have the ability to make these decisions alone. We have to consult with experts, which include government agencies as well as the medical experts in this regard. And when we do so, we minimize our risk. What about the duty to protect, in a general sense, the spread of COVID-19 once you have someone who has tested positive within your facility? What is our duty to protect customers or our guests from potential exposure? Again, this is about identifying the person who has been diagnosed with COVID-19, isolating that person if we cannot remove them from the premises at the time, quarantining that person and or immediate people who came into contact with that person, and then going about the business of disinfecting the areas of particular concern. So those would include, obviously, the areas where that person came into contact. Again, we go back to our first keys, which is consult your local agencies about it, consult the experts about it, and make a decision based upon what's going on in that particular hotel and given the current circumstances. So it's about making sure that you are following guidelines and complying with those regulations as well. And with respect to an overall general concern, which is how does the hotelier reduce risk while reopening? We talked about the guidelines. We talked about reliance on and consultation with medical experts and sometimes government officials regarding these decisions. But I will tell you that the general consensus of lawyers in the hospitality industry is that absent an outbreak or a specific cluster found at a particular hotel, that it will be difficult, an uphill battle, if you will, for a plaintiff to prove that they were exposed to COVID-19 against a particular hotel. So an individual bringing a claim that they were exposed to COVID-19 at a particular hotel is going to be an uphill battle to prove based on two factors. One, the issue of causation. What do I mean by that? So this guest that came to the hotel will have to prove that A, they were exposed to COVID-19 at the particular hotel, and secondly, that it was based on the hotel's failure to follow its own guidelines or the guidelines of other government officials with respect to cleaning, sanitation, safety distancing, wearing of protective personal equipment, and the like. And so that uphill battle is for that individual claimant to make a case of COVID exposure at a particular hotel. What is more challenging is when there's a cluster or there is a large group who have all been at the hotel and they all have been exposed at the same time. Those are a little bit problematic if, in fact, the hotel followed protocols and procedures. All right, so the next question is, what is our duty to protect employees from COVID exposure in the workplace? Again, the answer to that question is yes, we do, as hotel owners and operators who have employees in the hotel, have a duty to protect them from this exposure and to provide, in a general sense, the reasonable workplace safety. Let me start back over. I'm all discombobulated now.
Sorry.
All right, I'm starting this slide back over. Sorry. Okay, so the question here is, what duties does the hotel owner-operator have with respect to protecting employees? And the answer is the same and similar duties that you would have in a normal context. That is to provide a reasonably safe workplace. And so in the context of COVID, that includes adequate health surveillance. What do I mean by that? I mean the testing or screening of employees when they come into the workplace, whether that's through a quick swab test or that's through taking their temperature monitoring. All of those systems would be deemed to be reasonable. It also includes identification and isolation and quarantining vulnerable and suspected infected persons from the rest of the workforce. It means provision of suitable personal protective equipment to the employees. And in a general sense, a reasonable employer will ensure that it closely monitors advice from government agencies, industry bodies, as well as relevant experts regarding the changing climate of this disease and how to mitigate against those risks. So it requires management to stay abreast of the new and changing guidelines as they come out. It also includes following OSHA guidelines. We know OSHA guidelines apply in the workforce with respect to safety and protection of employees, and OSHA has promulgated specific guidelines as it relates to safety with respect to COVID. And so we have to be mindful that we need to comply with those guidelines as well. Remember that causation in any of these employee claims, just like the guest claims, is always going to be a defense. How is the employee able to establish that they in fact contracted COVID in the workplace is always going to be an issue in these particular cases. But the bottom line is, if you've kept abreast of the changing guidelines, kept in compliance with those changing guidelines, and done your best and taken reasonable steps to maintain a safe work environment, you should be just fine. The next topic I want to discuss is the issue of testing. The CDC has provided guidelines with respect to testing of employees, and they've issued essentially 5 guidelines that are deemed to be reasonable testing procedures or protocols if employed within your hotel setting with respect to your employees. And those include testing of employees who show symptoms. You can test those employees if they're showing symptoms. You've taken the temperature check, they're showing symptoms, you're able to make sure that they are tested, whether that be within your facility through the help of a medical professional that you bring in, or by sending them to a medical facility that's outside of the hotel setting. You can test employees who have been exposed to the virus. You can test all employees each and every shift. The CDC says you can test previously positive employees before they're allowed to return to work. And you can also test randomly throughout the facility to ensure or to test or check for hotspots within the workplace. So all those testing methods have been approved by the CDC. And again, check with your local guidelines as well to confirm that these are appropriate in your particular setting. So in summary, the bottom line is that if businesses use reasonable care to protect their guests and employees from the risk of contracting COVID, you are going to be just fine. We saw where those reasonable steps come from. They come from the guidelines from the CDC, the WHO, World Health Organization. They come from our industry guidelines. They come from our internal policies and procedures. And we use warnings as well to advise guests of any particular risks associated with our particular hotel or hotel setting. We can utilize waivers where appropriate if the guest is participating in a particularly risky event. Sometimes waivers might be appropriate in this context. And we can use testing to ensure that our hotels are safe. Remember that causation is always a defense. It's going to be difficult to prove in these cases unless there's a large outbreak or a cluster at a particular hotel. Comparative fault is going to be a good defense, and it will apply based on the fact that the government and medical experts have all made everyone, at least within the U.S. and throughout the world, in fact, aware of the risk of contracting COVID-19, and that these claimants, in a general sense, throughout the nation, will need to prove not just exposure, but actually that they contracted the disease or suffered some physical harm. I hope this is helpful in your quest to minimize your risk with respect to COVID-19 cases and lawsuits that may come your way. And if you have any questions, please feel free to reach out to me. Thank you so much. Have a great day.